Hi, everybody. So this is it. This is week 5. You are done after this week. So I hope you've enjoyed the course this semester or this short summer session. But this last week, we're going to tackle what is a jury and how are they picked? Because juries are a vital component to the criminal defense process within the court system. So today, this last lecture with me we'll talk about it as a constitutional right. Why is it in the Constitution? Followed by the process of voir dire and civil versus criminal juries, and then key points to consider in juries. And then last but not least, issues with them, because there's always issues, right? Nothing is perfect. So to begin with, let me move my head over here. It is indeed a constitutional right to have a jury, but not in every situation, in certain situations. So specifically, the right is contained within the Sixth Amendment. So that's its home. And in the Sixth Amendment, it says in all criminal prosecutions. So why am I emphasizing that word? Because there's two types of cases that you guys should know. There's criminal and there's civil, right? So it's two different types of avenues that you could potentially go down. Now, if you are a criminal defendant, you are being accused of committing a crime, then ding, 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 you get that jury. But if you're in a civil matter, meaning you're being sued because you didn't pay your rent or you broke your lease or something of that nature, then you don't have a right to a jury. You have to pay for one, especially in Texas, Louisiana. You'll have to request one. It's not guaranteed and it's very expensive. So note that a jury is not a right in every type of legal matter. It is a privilege in a civil matter, and it is a right in a criminal matter. Good exam question, right? All right. So specifically, it guarantees a jury in all criminal matters, and the accused shall, know that word, shall enjoy the right to a speedy and public trial by an impartial jury. Now, we kind of tackled this already, remember, where we discussed when a case can be removed. It can be removed because you don't have an impartial jury, or two, not one, two. There's just a better place. There's a more convenient location, right? But the theme of this week is the jury that you have a right to as a criminal defendant. What are they? Who are they? How are they picked? What are their responsibilities, right? So you may think you know, but let's dig into this a little bit further, right? So first and foremost, in order to even have your jury, you have to go through a process of voir dire. Now, it's funny. I feel like this word is kind of like tomato, tomato. I've heard some attorneys in my previous life as an attorney say voir dire, which is what I say. And then you hear some say voir dire. I would say it's voir dire. That's kind of the anthem, the term that I learned in law school and in practice. But again, tomato, tomato, you see it and hear it in different ways. But nonetheless, you can read that as I explained to you what voir dire is. But essentially, it is the process of picking out your jury. Okay. A jury is not automatic, meaning you have to go through a picking and choosing. It's kind of like match.com, right? You're swiping left or swiping right or whatever direction you guys swipe. I don't know. But you're going through the process of finding that perfect jury, because a jury can make or break a case for you, whether you're on the plaintiff side or on the criminal defense side. Your goal is to get the best jury you can for your side, right? So this is an interesting process. So during the process, first and foremost, you have a jury pool, and this is called your venire. Okay. So the venire is the smaller group that's chosen from the bigger pool. So I'll give you an example. Let's say in Nueces County, they typically pick their jurors, their potential jurors from voter registration. That's kind of the bulk of where they pick their potential people, right? And you may have gotten in the mail something that says you've been chosen for jury selection. Woo! Right? And you know what's sad, guys? I really do want to get picked as a juror, and I never am, because they're like, oh, you're an attorney and now you're, blah, blah, blah. And I'm like, please, I'd love to sit on one. Please let me sit on one. But they never do. Anyway, neither here nor there. So you get that initial invitation, and that is part of the big pool, right? You're part of the big pool at that point. And then they get it smaller and smaller and smaller and smaller and smaller. And how do they do that? Through a questionnaire. So this is where you may, for those of you who have done this before, you go down to the courthouse, you see a bunch of other folks that have that same invitation, right? Saying, hey, lucky one, you're a part of a potential jury. And you sit together and you fill out a questionnaire. This questionnaire is designed to determine whether or not you should be in that smaller pool of people, right? And it'll ask you, what's your education? What do you do for a living? And it'll ask you more specific questions. So one of the questions it may ask is, how do you feel about the death penalty? Now, Texas, we say it's A-OK for the death penalty in the state. We are, in fact, a death penalty allocating state. So if you're going to potentially sit on a jury in which death penalty is on the table, they'll want to know whether or not you are adamantly opposed to it, or if you're like, woo, let's send them all to death. They'll want to know that, right? Because you actually cannot sit on a jury that is contending with whether or not to sentence somebody to death if you're 100% against it. You shouldn't be on that jury. That's an actual constitutional rule. So they'll ask you whether or not you have any religious reservations, or if you're just adamantly opposed to it. And if you are, then most likely they're going to kick you off, because you need to be what's called death-proof jurors, which means you're okay with sentencing somebody if the facts and circumstances allow, right? So that questionnaire is very important. And so once they submit that, then it becomes even smaller. And at this point, hopefully, you'll have the judge that'll introduce him or herself and say what the role of a jury is. Juries are extremely important, guys. The founding fathers, there was a method to their madness. They wanted to have a jury in place because prior to juries being a constitutional right, in Great Britain, you didn't really have a jury of your peers. What you had was a bunch of rich folks, mainly men, well, actually all men, that determined your fate, right? As it most likely somebody who wasn't at their same social status. So the founding fathers wanted to do away with that. And irregardless, juries initially were still all men. The goal was to have an impartial jury, meaning they weren't all rich folks. They weren't all lawyers. They weren't all attorneys. They were a buffet of occupations, right? Which arguably what they hoped would present a more neutral party, a more neutral group of individuals to judge somebody's fate, right? All right, so the judge goes into that, and they'll explain the purpose of voir dire and outline the rules and expectations. Now, the rules and expectations today have gotten really tough, and I'll tell you why. Luckily, when I was practicing law, it was an issue, but it wasn't quite as much of an issue as I think it is today. But what do you think the biggest issue is in regards to jurors being quiet and not talking? Social media, hands down. So the judge will most likely really emphasize the fact that they're not to get on social media and get any information about the case, nor are they to relay, meaning post anything about the case or anything relating to the case. Now, why do you think that is? Well, there's a lot of cuckoo for Cocoa Puff stuff out there, guys. And you don't want somebody on TikTok, for example, to say, oh man, this guy, he is guilty with a capital G. And I hope that any juror listening to me right now will just lock him up, throw away the key, right? You don't want that undue bias, that prejudice that might set in if the jurors are exposed to misinformation, which misinformation is a big deal right now. Social media, there's no filter that says, hey, this story that you're reading is bogus. There's not anything like that, unfortunately. So you don't want somebody to say, oh, you know what, to other jurors, we should do this because I saw on one of my platforms that blah, 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 right? And that just completely crumples up and throws away all the hard work and the real information and facts that people who are educated and skilled and trained in the law are there to do their job, to present it to the jury, right? That's the attorney's job, is to relay that information to the jury so that they can make a value-based decision, right? All right. So the attorney, at this point, they are tasked with asking questions. Now, I want you to think about this. You have the prosecutor, you have the criminal defense attorney, and their role is to ask those jurors potential questions so they can determine whether or not that juror is or is not a good juror for their client, for their role, for where they're standing, right? So they want to determine if they, let's say, have a Black defendant, whether or not that potential juror is racist. Do they have any prejudicial thoughts? And there are questions that are asked in order to uncover that, right? And what's interesting is each side, prosecutor and defense, are allowed a certain number of what's called peremptory challenges. Now, basically what this is a get out of jail free card. You know, if you've ever played Monopoly, you get in jail, but if you have that card, you can get out, no questions asked. Well, peremptory challenge is kind of the same thing. You can kick that juror off without any justification. I'm going to say that again. You, as the plaintiff's attorney or the criminal defense attorney, can say, I want number 4 stricken. And nobody can ask you why. And there's no justification that's needed. Now, factually, legally, you're not supposed to use those peremptory challenges to discriminate based on race, ethnicity, sexuality, religion, other characteristics or demographics that identify a person, right? Or that a person may be identified through. But does it happen? Absolutely. Absolutely. And I'll give you an example of that in just a minute. Now, if you're looking for a potential position of employment, I know a lot of you are psychology majors or minors, or you may have an interest in that. And there is a role for you that a lot of people don't know about. It's called a jury profiler. Now, this person's entire role is based on understanding people enough that they can be hired by an attorney to sit with them during voir dire. And their whole job is basically helping that attorney pick out the right jurors for their client, meaning they can help that attorney understand who to keep on the jury and who to kick off the jury that will best serve the client at issue. So if you're on a death penalty case, what do you think some things that the jury profiler might look at in a person sitting in the potential jury pool? They're going to look for any type of religious affiliation. So if the person's wearing a cross, do you think that they would want that person on or off a death penalty case? Most likely off. Because if you are wearing that, a jury profiler might come to the conclusion that if you're wearing that, you're most likely going to be against the death penalty, right? Most likely. Now, the other things that they might look for is, let's say there is a mechanic that's on trial for murder, right? And murdering somebody who, I don't know, I'm trying to think of something similar. A mechanic who murdered somebody who was caught stealing from them in their store. What are some of the things that the jury profiler might tell that attorney to ask those potential jurors? Do you own a business? Why do you think they would ask that? Well, they would want to know if somebody else owns a business, they may empathize with that defendant, meaning, man, if somebody stole from me and messed up my business, I'd want to kill them too, right? So these are things that the jury profile is tasked with doing. They set out the roadmap for that attorney to get the best jury possible, again, for his or her client. So if you're interested in that, I included a link in the PowerPoint slide here that tells you how to become a jury profiler. And if you're really interested, let me know, because I know a few folks in the Houston and Dallas area that I can connect you to that you can ask questions to, and it's a fascinating area. All right. So remember how I mentioned the very beginning where we're talking about juries being a Sixth Amendment constitutional right in criminal proceedings? Remember, they're not required in criminal and civil, just criminal. Civil, it's a possibility. Criminal, it's a must, right? So if you have a dispute over a contract, property right, personal injury claim, or breach of warranty, the right to a jury trial exists, but that means that the civil defendant has the option to request the jury. And it can be costly, guys. Again, in a civil trial, you have to pay those jurors to sit and listen to your case. So that's why a lot of times in civil matters, the defendant may not want to, or the plaintiff may not want to bear the burden of the cost of a jury. And they may say, screw it, I don't want a jury. I'll just go with a bench trial, which means the judge. The judge is the ultimate decider. But there are certain types of civil cases where a right to a jury trial may not be guaranteed or may be very limited. And that includes in small claims court. So some of you may have been to small claims court. So they typically handle small matters, right? So if, let's say, you're a landlord and your tenant owes you $300, that's a small claim. That's not a big claim. So you're going to be in small claims court. And because it's such a small claim, your right to a jury trial doesn't exist. You have the option to a jury trial, but even then, in a small claims court, they may not grant you the opportunity to get that jury because it's just not worth a jury's time. $300 is very little in the eyes of the law. So the second area in which a jury trial may not be guaranteed or may be very limited is equitable remedies. So in some cases, instead of seeking monetary damages, such as monetary damages, you're instead seeking like an injunction or specific performance. And I'll give you an example. I handled a case in Louisiana in which I represented a pig farm. And this pig farm was stellar, guys. And when I say that, I mean, this guy worked his booty off to make this the most clean, humane operation that you can potentially even imagine. I was amazed. And I am not a big fan of, I like bacon, but I'm not like a big ham fan. But neither here nor there. They built a subdivision right by his farm, and his farm had been there, by the way, since the early 1900s. So his family had generationally farmed this specific piece of land, and he was the first one that said, you know what, I'm going to do this in a humane way. And his pork is actually sold at Whole Foods and other big places. Very nice man. But his neighbors that just built this, like, and I call them vinyl villages, guys, but you know, the housing developments where everything looks the same. Well, they had built this subdivision right by his property. And then they complained because they're like, it smells like pork. It smells like pig. Well, shocker, you built your subdivision right next to a pig farm. Anyway, so they were suing him not for money damages, but they wanted to actually stop his farm. They wanted him to stop, to cease farming. Luckily, I was able to save his farm. Hence, I got this really cool portrait in my other room that he painted me of pigs, and my husband hates it. He's like, please take it down. But I love it because it makes me happy. But in that case, there was no jury. I didn't even argue to a jury. In fact, I literally went to the judge's chambers, meaning his office, and said, look, you can't shut down his farm because of this statute, this statute, this statute. And the judge said, wow, I can't believe you found that. Because I found an act called the Right to Farm Act of 1908. Yeah, I did some digging in order to have the case dismissed. So there was no jury in that case. It literally was me going up against another attorney who was like, oh, crap, I didn't even know that existed. That's a good point. The third area is administrative proceedings. And this one, it's usually a regulatory dispute, licensing dispute. And again, in those cases, you're not dealing with a criminal matter. Nobody's going to jail. And it's usually somebody saying, you know what, you violated this regulation, and it's more administrative. Okay. So that would be akin to trying to think of an example. If you, as a refinery, did not submit the right paperwork to increase the amount of, let's say, some certain chemical out into the smokestack, then the EPA might come after you, or the TCEQ. Doesn't matter if you don't know what that is. It's okay. My point is it's special agencies that come after you. They don't have juries because they are the experts, and they're saying, hey, you violated this regulation and you owe this fine, right? No juries involved. The last is arbitration or mediation. Now, this is a huge deal. And for those of you who want to go to law school, I sincerely hope you consider becoming a mediator. It is funny money involved with it. Just putting that out there, guys. I always like to introduce students to potential career paths, and mediators make funny money, and it's a great job. Basically, it's two parties who come together and they don't want to go to trial. The goal is to not go to trial. So a mediator, arbitrator, their job is to try to prevent it from going to trial and get the parties to agree, to come to some type of an agreement, right? So they're basically saying, hey, you chill, let's talk this out. They're not on this party side. They're not on this party side. They're on the side of coming to an agreement, right? So in that case, there's no jury because it's not a trial. It's, again, behind closed doors of an office room, meeting room in which the parties chit and chat in order to come to some type of an agreement without going to trial. Okay. So these, again, these are for the primary areas in which you typically don't have a jury. All right. So what are some key points about a criminal defendant's right to a jury? Because remember, as a criminal defendant, you are entitled to a jury trial under the Sixth Amendment of the United States Constitution. So with this, you have the right to an impartial jury. Okay. The goal is to have an unbiased jury. You don't want somebody that says, man, I hate blondes, and if I see a blonde defendant, she's done. Right? You can't have that, or you shouldn't have that. So the second is they are tasked with determining guilt. They're what's called the fact finders. And this is extremely important, guys. You have your judge and you have your jury. The jury determines whether or not Professor Callie sold meth to students on every Tuesday at Whataburger Field. I don't. But that's what they determine. Is that true or is this false based on the information, the facts that are presented to them at trial? The judge, on the other hand, determines whether or not the law was applied properly. The judge is not tasked with determining facts. Nope. They will just look at let's say, possession and Schedule 1 trafficking charges, were they properly applied to this case based on what the jury found? Or is the law being applied properly? So judge is the legal finder, jury is the fact finder. Judge, law, jury, fact. Judge, law, jury, fact. All right. So they also have to determine whether or not the person is guilty beyond a reasonable doubt, which is the highest of high standards, guys. Meaning, if you're going to take away somebody's life or their property, then you better be darn sure that you are correct, which is why, again, the jury, they can't just say, you know what, I kind of think they did it. Let's be safe and just put them as guilty. They can't do that. They have to say, you know what, this is beyond a reasonable doubt. The facts show that, yep, this person did the crime, so they should do the time. Now, the size of the jury varies. Typically, it's 12. So I'm gonna make it easy for y'all. It should be 12. Sometimes that varies, but most of the time it is 12. Now, their decision has to ultimately be unanimous, especially for criminal cases involving a life sentence, a death sentence, has to be unanimous, meaning all 12 of those jurors have to agree. The next thing is their deliberations. So it's interesting. This is the part where there's always a lot of back and forth by attorneys by saying, like, if they meet for a little bit of time, that means the defendant's done. If they meet for a long time, that looks good for the defense. So there's always a lot of speculation about whether or not jurors who deliberate for a short time or a long time, whether or not that means it's good or bad for the defense. So just know about that. It's just kind of an interesting debate in the legal world. But typically, after they hear all the facts and all the information presented to them by the attorneys, they go into deliberations, meaning they chit and chat amongst one another about what they heard, what they thought, in order to ultimately come to their ultimate conclusion of unanimous guilt or not guilty. Now, again, the role of the judge is what? Legal finder, not fact finder. So make sure you understand that, because that would make a really good true or false question, don't you think? All right, so like everything, and I mentioned this at the top of this lecture, there's issues with juries. There's been issues with juries for many years. One of which I'll just put out there is with the jury profiler. Jury profilers are tasked with picking out the best of the best jury based on their client needs, right? Well, they're not cheap, they're expensive. So are the only people that are able to really get the best foundation for their case the wealthy? Food for thought. But the other thing is bias and prejudice. A lack of legal knowledge. They're not legally savvy, so maybe they don't understand specifically what they're being tasked to address or what laws to apply. Juror misconduct is a very big issue, and group dynamics and deliberations. There have been some horror stories that have come out of jury deliberations, meaning some jurors are just like, screw you, I am going to stand my ground. I think he's guilty, period, the end. I do not agree with y'all. So if you have somebody with a really strong personality, that's going to impact the jury deliberations. Have you ever been in a group situation in which there's one person that's like, no, we should do this and I'll do this, and they set it up, but pretty much the entire group doesn't want to do what this person wants everybody to do, but everybody does it just to not have to fight with that person? Well, can you imagine that in the jury context? It's also lengthy and costly, meaning it is very expensive to have a jury. And so a lot of times the court will try to speed through the process in order to reduce the cost of the jury. Complexity and sensationalism. Now more than ever, cases are becoming more media and emphasized, sensationalized. There's court TV. The first court case that I ever remember vividly seeing was the O.J. Simpson case. Everybody was glued to their televisions when regards to O.J. Simpson. And then further past that, you had the infamous case of Casey Anthony and the murder of her daughter, right? And when she was found not guilty. So you also have to contend with, we tell jurors not to become influenced by others. But good grief, the amount of information that we are bombarded with on a daily basis, on TV, on social media, online, it's almost overwhelming. So is that realistic to think that we are devoid of all bias and all prejudice when we walk through those courthouse doors? I don't know. And also having inconsistent outcomes. You can have the exact same case with the exact same dynamics between two different counties in Texas, and they may come to drastically different results. Is that fair? So here's an example of jury misconduct, a real case of jury misconduct I wanted to introduce to you. It is the case of U.S. versus Thibodeau, which always harkens back to Louisiana for me, but Thibodeau, old case, 1994 case in which sadly a 12-year-old girl had disappeared. They eventually found that she had been murdered, and this was in New York. Her name was Heidi. Isn't that a cute name? But poor Heidi was allegedly murdered by two brothers, and they were charged with her kidnapping and subsequent murder. Now, the prosecution presented what's called circumstantial evidence against them, but there's no direct evidence linking them to the crime. Pause. You should be asking, what the heck is circumstantial evidence? That means there's nothing to say that those two brothers were seen with her, that there's no evidence of her having been with them, there was no DNA evidence connecting to them. Rather, circumstantial evidence means they were seen in the area. Okay. So basically, it's information or facts that indicate that they were maybe in the area or that they could have done it, but nothing direct. That's circumstantial evidence. So years later, a new witness came forward, and this new random person said, look, it wasn't those two brothers. It was actually this guy, James, who confessed to me that he kidnapped her and he murdered her. So this, of course, raised properly some legal questions about the two brothers' convictions. Now, it also came out that during the initial trial against the two brothers, that multiple jurors just acted terribly. Specifically, one actually did her own investigation. She went to the crime scene. She interviewed witnesses. She started talking about the case to neighbors, looking into different people. And then she went back to the jury and she told the other jurors everything that she had found. Okay. And she's not an investigator. She's not trained in these matters. So basically, based on that, the conviction was overturned of the brothers. So basically, what this case indicates, the Thibodeau case, which should be in your heads, reflecting jury misconduct, is that you need to have an impartial jury. It's vitally important. And you need to have a jury that adheres, means follows court instructions. They can't go out and become, Sherlock Holmes. They're no Sherlock Holmes. So it's very important to keep the integrity of the case. The second case that I want to bring to your attention, and let me just minimize my head so you can see this, is the case of Curtis Flowers. Now, there's a podcast about this, and I'll link it in this week's module if you're interested in true crime podcast, because it's fascinating. But he was actually tried 6 times for 1996 murders of 4 people that worked at a furniture store in Winona, Mississippi. Now, if you've ever been to Winona, Mississippi, you blink and you miss it. It is a very small, impoverished community. There's not a lot going on there, but the people are extremely tight-knit because it is so small. So during the first 4 trials of Mr. Flowers, the juries were predominantly white, and he was convicted each and every time. Okay. Now, these convictions were subsequently overturned due to prosecutorial misconduct. Specifically, the prosecutor was found to specifically try to get all the Black people off of the jury during voir dire. He did not want any Black jurors. Why? Because he thought that it may make them more likely to empathize with Mr. Flowers. So what's interesting is during the fifth trial in 2010, the jury was once again almost all white. And the key point of contention in this case was the peremptory strikes. Remember, that's the strike in which prosecutors or defendants can kick somebody off a jury for no reason. They don't have to justify it. So the prosecutor struck a total of 10 out of 11 eligible African-American jurors, resulting in nearly an all-white jury, meaning they had one Black person out of the entire jury. Whoops. Now, the defense raised objections, and they said, basically, look, court, he can't do that because there is a Supreme Court case called Batson versus Kentucky. And that case set the stage. That case is the one that said, look, you can have your peremptory challenges, but you cannot kick somebody off a jury because of their race or their ethnicity. You can't do that. So the defense raised these objections, but the trial judge controversially basically said, yeah, it's okay. We'll just let it stand. So subsequently, the Supreme Court stepped in 2019. So this is very recent. And they ruled that the prosecutor's repeated use of peremptory strikes to remove African-American jurors from the trial was indeed motivated by racial bias, and it violated the Sixth Amendment right to an impartial jury. So they overturned his conviction, citing the clear pattern of discrimination in the jury selection. Now, if you're asked about this case in the exam, know that this is the case that highlights racial bias on jury decisions. But also note, let me stop here. Also note, though, that it's really hard to prove to support an argument that somebody was stricken because of race or ethnicity. Typically, when this happens, and I've seen it happen many times, whoever uses that peremptory challenge may say, oh, no, it's not because of their race. It's because, we need somebody with less education. Or on the flip side, they may say, we need somebody with more education. So they'll point to something else. To prove somebody's intent is nearly impossible, guys. So that's why this is still an issue. It's something to still consider, and it's still a problem within our jury selection process. So there you have it. That is Juries in a Nutshell by Dr. Shaw. And I hope you guys have enjoyed this term. Make sure, though, you're not done yet. You still have your final exam and your discussion for this week. If you guys have any questions whatsoever, please reach out to me. I'm here for you. You can call, you can text, you can email, send smoke signals, whatever floats your boat. And it was a pleasure to teach you all this term. Adios.